Hello everyone, my name is Cassandra Janicki and I'll be your instructor for business law at Columbia College. This is our first recorded lecture. The purpose of the first 2 weeks of class is to orient you to the legal system, give us all a good baseline for where we start with our legal knowledge, and then we're going to jump right into the biggest brick of knowledge that we're going to hammer this semester, which is contracts. So today we'll go over chapters 1 and 2 from your textbook, and then in our next class, class 2, we'll go over chapters 4 and 6. Now, to start, chapters 1 and 2, again, focus on that baseline knowledge that we all need to have moving forward in this class so that we're all using the same types of words to reference the same types of things. So first, what is the law? That's a harder word to define than I think a lot of people think about, because what does that mean? What is the law? Well, I can tell you that it's an order or pattern of rules that we as a society have established to govern how we interact with each other, what our relationships are with each other, and how we can respond if those relationships are broken, if they are damaged. And so the law really provides us with that order, right? Law and order. But the law also defines for us what our rights are and what our duties are. So a right is a legal capacity to require another person to perform an action or to refrain from performing an action. So a lot of folks will think about the Bill of Rights when we start talking about rights, and that's a perfectly good place to start because our Constitution has codified or put into law a series of rights that we as American citizens have. Corresponding to those rights, however, are the duties of others to not infringe on those rights or their duty to govern our rights. And so a duty is an obligation of the law that is imposed on a person to perform or refrain from performing a certain act. So the way that I want you to think about duties and rights is that they are a yin and a yang to each other. One cannot exist without the other, because if you don't have a right, then nobody has a duty to not do something to you or to do something for you. And then conversely, if there's nobody who has a duty to do that for you, you don't have a right. And so this is a yin and yang relationship that's defined by the law. A good place for you to think about and to really conceptualize the expansion of a right is dealing with the rights of privacy that we have. So there isn't any one blanket, hey, you have a right to privacy. But what our law has done is that it has conceptualized our right to privacy in a bunch of different areas of the law. When we get further on in this lecture, we're going to talk about the variety of places that you can find the law, where it's been put into writing. But a great place for you to start, particularly for the right to privacy, is in our Constitution. So the Fourth Amendment protects you, an American citizen, from unreasonable searches or seizures of your person or property without a warrant. So that's your right, right here. However, the corresponding duty is that the government does not have a right and has a duty to not invade on your right to privacy. The way that that duty is enforced, and if people violate your right to privacy under the Fourth Amendment, is called the exclusionary rule. So if an officer walks into your house without a warrant, does a search of your property, and finds incriminating evidence against you, you can go tell the judge, hey judge, listen, you shouldn't allow any of that evidence to come in. You should exclude it from the case because law enforcement violated my right to privacy. See how that works out? And correspondingly, law enforcement had a duty to follow the law, not violate my right to privacy, and get a warrant, and they didn't do that. So you need to exclude that evidence from contemplation by the fact finder, so the judge or the jury. A great place where we're seeing and where we have seen in the last several years this right to privacy and the Fourth Amendment really expanding and protecting more areas of our lives deals with electronic devices, right? Right now, I'm talking to you on my personal laptop, and by doing that, I'm potentially exposing my right to privacy, the contents of my computer, to your potentially prying eyes, right? And so when we started to use super complex devices, right, like cell phones, my whole life is on my cell phone. The law didn't know how to handle those types of devices. They didn't know how to handle this advance in technology. And so it used to be, in the good old days, that if you stopped a person during a traffic stop, you're a cop, and you stop a person during a traffic stop and you think that you have evidence showing that they may be involved in the sale of narcotics, okay, dope dealer. Before 2014, you could just take their phone, open it, however you might do that, and just start searching through their text messages and their cell phone records. That happened to a gentleman by the name of Riley in Southern California. And basically, he gets stopped during a traffic stop. They think he's a dope dealer. They do a search of his phone because his phone is blowing up. So they find evidence of narcotic sales on there. They had also been stopping him, not just because of the dope, but because he had been involved, they suspected, in a shooting sometime before they stopped him. So they also wanted to take a gander at his cell phone records to see if they could pinpoint him anywhere near the shooting. So Mr. Riley is offended by the fact that they get all of this evidence off of his cell phone. So he makes a motion to exclude, under the exclusionary rule, all evidence taken from that cell phone because it was in violation of the Fourth Amendment, he claimed, because the officers didn't get a warrant to search his cell phone. California trial court said, sorry, dude, cell phones are not contemplated anywhere in the Fourth Amendment. We haven't contemplated them as an object that can or cannot be searched in our state law. And so you are SOL, my friend. That's too bad. So they denied his motion to exclude the evidence. So he pleads guilty, and he appeals the ruling on his request to exclude evidence all the way up to the California Supreme Court. And the California Supreme Court says, hey, listen, this is too big of a question for us. Because what this really does is it implicates a question of United States constitutional law. So they're like, hey, United States Supreme Court, please take this case. So the United States Supreme Court looks at it and comes to the conclusion that because of the advances that we have had in technology, our cell phones, our digital data, our digital devices contain almost more information about us than you may sometimes find in our own homes. And so as a result of that, the United States Supreme Court said, cops, you did a wrong thing. You couldn't search his phone. If you were going to search his phone, you needed probable cause and a warrant, and you didn't have either of those things. So you know what? That evidence is out. Now, this has an incredible trickle effect, because when you think about it, and we'll talk about this when we get into the court systems a little bit, the United States Supreme Court is the penultimate, the end-all, be-all of decision-making in the American legal system. And so when they said, listen, you need a warrant for every cell phone or digital device that you search, whew, did that change how we operated in law enforcement? It necessarily had to, because again, good old days, you could search that stuff no problem. No longer. So California, and we'll talk about this often enough during this class, California has a special flower, and it always likes to be different, and it always likes to be more on the cutting edge of things. So it passed CAL-ECPA, which is the California Electronic Communications Privacy Act. And what that did was it put into place the most significant electronic communication privacy law in the entirety of the United States. So literally, if you are getting into somebody's digital information in the state of California, you have provided adequate probable cause for a specific date range of information, and you can't go ahead of that and you can't go behind that. It is the most expansive and protective Electronic Communications Privacy Act in the entire United States. Even more stringent than the federal version, which came before CalECPA, and CalECPA went way crazy. So you have this right to privacy against state actors, right? The police, the government, you've got that right under the Fourth Amendment. The larger problem with the Fourth Amendment, which we'll talk about in a little bit, is that the courts have eliminated a good portion of the things that are protected under the Fourth Amendment as being protected under the Fourth Amendment. So the Fourth Amendment case precedents that has come out since the advent of the Constitution has really worked at increasing the ability of the government to get into your stuff without permission. It's fascinating. We'll keep working through that. Now you may ask yourself, well, Cassandra, what about my right to privacy from other people, not government people, private people? I want my privacy to be protected from Joe Schmo the Ragman walking down the street. Great question. Here's the deal. You do not have a right to privacy against other private actors. You don't have a blanket rule that says, hey, listen, you are protected from other people invading your privacy. But there are person-based laws, so certain people can have the right to privacy from other people, and those are delineated by the state legislators. There can also be conduct-based laws. My favorite is the revenge porn conduct law that California passed 3 years ago, where it makes it a misdemeanor for you to utilize an explicit photograph of someone with whom you had a prior relationship with and who gave you that photograph in the privacy of your relationship. It's illegal for you to post it, send it, give it to other people without that person's permission. So while there are areas of your lives that are protected from other regular people, those are, again, passed and utilized at the state level and at the federal level. The reality as well is that technology has really eliminated our ability to A, keep anything private, but B, for us to say that the things we post on social media are private. And so a great example that I think about in reference to that is the concept of social media getting you fired from your job, right? So a lot of people utilize social media to pop off, to rant, and to rave. I don't know if any of you are members of the Tuolumne County rant page. It's crazy. But people will say just about anything behind a computer screen. And so employers in particular look at your public social media content. And the larger question becomes, what's private and what's not if your privacy settings are strong enough for them to utilize your posts against you as a reason to terminate? I would submit to you that they can. They can all day, and there doesn't even have to be anything in your employment contract to disallow that. You may think, hey, listen, I have a right to free speech, and that may be true, but they also have a right to fire you. So, things to keep in mind moving forward. Now, as I mentioned, there are a variety of places where we get legal content, right? Where we get the law. So, biggest, highest, most on top, constitutional law, okay? A constitution is a body of principles that we utilize to establish how our government is structured and our relationship with our government, right? Government, people, Constitution, this is how we integrate with one another. Typically, written document, okay? We all know that we have a written United States Constitution. Interestingly enough, if you go to other constitutional countries, because not every country operates under a constitutional law basis, France is a great example. They pass a new constitution like every 3 years. It's crazy. On the other hand, we take a damn near I mean, the entire United States has to agree before we can amend the Constitution. I mean, it's crazy. So we have that written document, but obviously, like in our country, the written document doesn't change. So how does the body of constitutional law and case precedents change? Well, it changes because we, in the law, judges, lawyers, cases, will change how we practice and how the Constitution applies to us customarily. As new issues arrive, great example, cell phones, as those new issues arrive, the Constitution and our interpretation of how the Constitution governs those new issues, that's where we get new constitutional law developing. You'll see here that I've also listed the concept of preemption. So we will talk about federal supremacy here in a little bit, but preemption is how federal supremacy is effectuated on the legal field. So if a state passes a law governing one area, and then the federal government passes a law that's in contradiction or more strict or less strict than the state law, that federal law, federal constitutional preemptive law, will reign supreme. So, if a state passes a law that is unconstitutional, it will be preempted by constitutional law. If a state tries to regulate in an area that the federal government has decided that they get to regulate, federal law will preempt more often than not. Stay tuned for how that might be different. So that's constitutional law, supreme source, right? Then you have statutory law. So if you were to walk into my office's law library, you would be confronted with multiple walls, all the way up to the ceiling, full of statutes, books with laws, book after book after book. Those are the laws that are created by our legislators. That can be our federal legislators, our state legislators, and even our local legislators. So a good example of federal legislation is federal environmental law legislation. Like almost exclusively, the federal government regulates environmental law. As I mentioned earlier, one of the places and ways a state can also regulate an area that the feds have already decided to regulate is by making their law more stringent than the federal law. So environmental law is a great example. California has the strictest environmental laws in the entire United States. Again, special flower. But the feds have, quite systematically, since 2016, worked at eliminating federal regulations and federal protections of our environment. So that's a really good example of where the feds have statutory law, the states have statutory law, but California's ekes up and is more strict, whereas the feds go down and their laws are less strict. Good example of local legislation. I hope that some of you are dog lovers, but the licensing requirements that we have in Tuolumne County to make sure that your pets are licensed. That is a local statutory construction, statutory law that we have to follow as citizens of Tuolumne County. So again, all the way at the bottom, all the way at the top, statutory law all throughout. Now, administrative law, we're going to have, that's what Chapter 6 is about. We are going to talk about administrative law. We're going to talk about administrative agencies. Super interesting, really neat. They're like their own trifecta of government. Geek out a little bit about the administrative agencies because I think they're really cool. But administrative regulations are promulgated or put forth, written, and adopted by administrative agencies. They're super cool. They have, those regulations, the same force as statutory law, but the administrative agencies don't have to wait for Congress to pass them and to argue about them. They do have to be approved by Congress, but typically, because we trust administrative agencies to really know what they're doing, Congress just passes them. It's good stuff. Now, private law, these are things that are typically going to be created by contracts. We're going to spend a lot of time talking about contracts. But private laws are ones that are generated by individuals for individuals, and that includes businesses. So when you sign, maybe some of you work for a county government or for a mid to large size business and utilize a computer that's provided to you by that agency. I would almost guarantee that there's a little thing on the front when your computer opens that says, hey, listen, we're watching. And if you do anything bad, we're going to find you. Right? That's a private law that they have created and that you have agreed to be bound by. Now, things that we're going to talk about less in this class, treaties and executive orders, simply because this isn't a government class. Sometimes I wish it was, but it's not. So, treaties and executive orders are imposed by the executive branch of government. We are in, and have been since the Obama administration, this huge flux of how we think executive orders can be utilized to govern areas where Congress or our legislators have historically been in charge. Immigration is a great example. So, as I note here, the scope of our ability to, the executive branch's ability to utilize executive orders is really in question, right? This will date this video, I'm sure, but President Trump just passed numerous executive orders for a coronavirus relief bill because Congress couldn't come to an agreement, and then they went on vacation. So, those are being challenged right now because a lot of folks are saying, hey, listen, it's really nice that you did that, but you can't because that exceeds your branch of government. It's really fascinating. Stay tuned. Uniform state laws are created by this National Conference of Commissioners. They have representatives from each state on these committees who talk about what the laws are in their states and how they think the United States as a whole should have a uniform code for those areas. So really these are purposed with creating a generalized business interaction so that how people do business in every state is consistent, because it's real confusing for you to have a Nevada corporation but operate in California. Whose laws are you following? What laws are you violating? It can be very complicated. We'll talk more about it, but at the end of the day, when you're able to utilize a uniform code, it makes things a whole heck of a lot easier. So the one that we'll reference most during the second half of our class is the Uniform Commercial Code. As I mentioned earlier, California is a very special flower most often. However, Louisiana is a quick second because they refuse to utilize any uniform codes, including the commercial code. And they still operate under a Napoleonic law for their criminal law area. And my favorite thing that I learned, they didn't require unanimous juries in criminal cases until 2018. Mind blown. Craziness to me. But I digress. Now, Part 4 for sources of law is probably the most important, but also the most complicated, because this is where lawyers get their little fingers in everything and they muck it all up. So the concept of case law, case precedents, is that when you have a new issue come up, and trust me, there are new issues every day, You have a new issue in the law come up, and either a law doesn't exist, or it may or may not fit under an existing law, or we as a people have changed, and we need the law to like catch up. That's where case precedents and case law changes how we think and apply the law. So I mentioned to you, right, about the Fourth Amendment and how it's awesome, right? You're protected from all these state actors. People have to get a warrant before they can come in your house, except under about 14 different exceptions. If there are that many exceptions, how great is my right? Well, each one of those exceptions came out of a new issue, a new situation that required the law, judges, lawyers, the Supreme Court, to look at the issue and say, man, how does this apply? And is there enough for us to say, hey, law enforcement didn't need a warrant? Question mark. So what case law does is it clarifies what statutes mean, because trust me, if you read, I don't know, section 290 of the Penal Code, your eyes would start to cross. I know mine do every time I try. Because it's super complicated and really poorly written, because not every legislator was a lawyer. So case law really provides us with clarifications for meaning and provides interpretation. It also creates this concept of precedence and common law. So even though the Fourth Amendment's language hasn't changed in the 300 years since it was written, 200? Math is hard, that's why I became a lawyer. 300, 200? We'll get there. Between 2 and 3? We haven't celebrated our tricentennial yet. And I lost my train of thought. One moment. Bringing it back. So even though the Fourth Amendment in its actual verbiage hasn't changed, our interpretation of it has significantly, but we don't go back and rewrite the Constitution. So what case precedence does is it develops this common law, unwritten principles based on our usage of the law, customary application of the law, and will then stand for what the law means in the future. So one case that I loved learning about in law school was the hot pursuit exception. So someone is running around chasing after someone who had just committed murder. And so he's running after this guy, and this guy runs through an open front door into a home that was occupied, runs out the back door, so the cops run in after him, and as they're running past a very large amount of cocaine just sitting out on the table. Huh. We'll be back for that, sir. We'll be back for that, right? And so, does the Fourth Amendment prevent the cops from entering your home and doing a search without a warrant? Absolutely. But we recognize that the inherent danger of law enforcement being in hot pursuit of a fleeing felon, we're going to let that one slide. And whatever they see being lawfully in your home to chase that person gets to come in and isn't excluded. That decision was made not by our founding fathers, but by judges who interpreted the situation and the law and came up with an exception to the rule. So, stare decisis is really the concept of letting the decision stand. Judges don't like to be wrong, folks. And if they are wrong, it's other judges that tell them they're wrong. So judges don't like to be wrong, but judges tell other judges that they're wrong. More often than not, judges don't get to be wrong. Judges aren't wrong. Because other judges say, ooh, maybe I would have made that same choice. the decisions of our courts stand for as long as they are good law. So until they're overturned by a different court under a different situation, that's the law. This page really just gives you some clarifications and definitions. So when we talk about substantive versus procedural law, what we're really talking about is how does somebody have to be brought to court versus what they're being brought to court for. Procedural is how you get there. Substantive is what you're talking about, the meat of the situation. Criminal law is obviously one that defines wrongs against society. So, for example, I'm a prosecutor, and when I make my appearance, it's Cassandra Jenneke for the people, not for Jane Doe 1. I'm not her attorney. I am the attorney that represents the state and our society as a whole. Moreover, civil law is really what defines violations against each other. So for example, if I entered into a contract with somebody and then I breached that contract, that's a civil violation. And then lastly, we don't really utilize equity anymore. Equity was a super neat concept in the English Commonwealth, where we really talked about what justice was rather than how we would have to get there. So they would look at a case and say, justice is you get half, and then we are done. Versus how we operate, which is not like that. So our American courts used to have courts of equity and then courts of legal remedy. But then we were like, you know what, that's too complicated. So now we utilize legal remedies and occasionally equity, but equity is a much more complicated concept, and we'll be talking about it pretty consistently throughout the class. So the second chapter, which is chapter 2, really talks about the court process, right? So we just talked about procedural versus substantive law, right? This is really the nitty-gritty of procedural law. So when we talk about jurisdiction, you'll see that I have it abbreviated to JX. So jurisdiction is the ability of a court to hear a particular case. It's their authority to hear a case. Subject matter jurisdiction references the types of cases that they can hear. Original jurisdiction is just referencing being at the bottom of the process, so our trial courts. General jurisdictions can hear everything, and then limited jurisdiction courts can hear like one type of thing. Now, when we talk about appeals, right? I'm sure you guys have all heard this word, right? So initial jurisdiction is initiated at those general trial courts, okay? So the appellate court is one level above them, and what they do is they review the work of the lower court. It's based purely on the trial court record, so you'll probably hear "for the record, Your Honor," sometimes in television shows, right? When we talk about the record, what we're talking about is the evidence that was taken at the trial court level. So the appellate court very rarely, so rarely, ever hears additional evidence. It's all based on what the lawyers and the trial judge did at the trial court level. An appellate court will, after reviewing the record and reviewing the applicable law, if they find that the lower court made an error that warrants reversal, it's called reversible error. I know. Define the word with the word, Cassandra, much. But that reversible error will send that case back to the trial court, and the appellate court will tell them to do it right again. Okay? Do it right the second time. Now, if the appellate court looks at it and says, that's good, you did a great job, they're going to affirm it. If they look at it and they're like, ooh, you made a mistake, but we can fix it here, they may just do a reversal with a judgment. Or if you messed it up bad enough that we have to send it back, it's going to be a reversal and a remand. Remand down back to the trial court. Now, the federal court system is very, has similarities and differences to the state court system. So every state court operates a little bit differently. So I'm going to structure our conversation most specifically around California. When we look at our federal court system, their original jurisdiction courts are called district courts. These are folks who will hear criminal matters, civil matters. The only civil matters that get to be heard at the federal level are cases where the United States is a party. So if it's United States versus Joe Schmo. If it's two different states that are battling each other and the value of their conflict is greater than $75,000. And then if it implicates a question of federal law. Now, our U.S. Court of Appeals, so the district courts are down here. U.S. Courts of Appeals are the next set up. We have 12 circuits. California is in the 9th. They are typically the appellate courts governed by 3 judge panels. But, for example, the 9th Circuit is enormous. I mean, it includes us, it includes Alaska, it includes Hawaii, it includes Washington, Oregon, Idaho, Nevada. And so we don't just have one set of 3 judges. We have the largest number of appellate court judges, federal court of appeals judges, who sit on 3 judge panels in different areas. So, for example, we have one in San Francisco, we have one, I think, in Los Angeles, and then all the other states have, you know, one or more depending on their populations. So once it gets to the U.S. Supreme Court, it's got one more level. One. And let me tell you, that's the hardest level to get to. This is where we have the appellate jurisdiction for our federal appeals courts and our state Supreme Courts, as I explained in Riley, if the U.S. Constitution or a federal court ruling has reversed that issue. So if it implicates an issue of federal law, that's where it's going to go. So the U.S. Supreme Court is also super neat in that it can be the court of original or trial jurisdiction in cases dealing with ambassadors and in cases dealing with 2 or more states. So a really interesting original jurisdiction case dealing with multiple states was all of the litigation over the Colorado River. It's fascinating. So in order to get to the U.S. Supreme Court, you have to file what's called a writ of certiorari, or you have to appeal, and then they will issue a writ of certiorari granting you permission to be heard in the United States Supreme Court. It's real hard to get there. They get over 7,000 requests for review, and they will take less than 150 every year. So your case better be pretty darn important to get all the way up there. Now, as I mentioned, California, similarly situated, we have general jurisdiction courts at the trial court level, we have appellate courts, and we have the California Supreme Court. But we in California also utilize specialty or limited jurisdiction courts. So if you've ever had a family law case, family law court, that's a specialty assignment. Probate, also a specialty assignment. Juvenile law, so either juvenile delinquency or juvenile dependency, all limited jurisdiction courts. It used to be that we had multiple levels at the superior court level, at the general jurisdiction level. But in 1998, we recognized that that was way too expensive and that we couldn't really afford that anymore, so we consolidated. We utilize small claims courts where there is a $7,500 limit, and where the parties cannot have any attorneys. And then, of course, we have the appellate courts and the state Supreme Court. Now, there's a whole heck of a lot on this screen, and your book does a good job of walking you through this process. Things for you to be aware of. ACP means attorney-client privilege. Take a gander at the area of conflict of law. That's super important when we start talking about contracts. Less so do you need to know how to commence a case, but my favorite part to talk about in civil cases is discovery, because I think it's awesome that when you're a civil attorney, you get to know everything up front before you even go to trial. And the way that they do that is through the discovery process. Now I'm going to show you a really fascinating display of lawyering during a deposition.
Did you talk to this man sitting next to you before this deposition started? yesterday, but he had nothing to do with
I didn't ask
you
you
are
that.
currently saying. I said it, though, didn't I?
Did you talk to him, sir? What'd you say?
I said nothing. I said, you have a case of incipient verbal diarrhea.
Oh, sir, we're going to see about that.
Well, good.
Did you talk to him yesterday?
Yes.
How long?
About 3 hours.
Talk about this case?
Yes.
Did you tell him the other companies you consulted for?
No. I did.
You're under oath here.
I did not.
We'll see about it. When you were at Monsanto, what was your title?
At Monsanto, what do you mean?
In Texas City.
Research chemist.
And was that your title during your entire stay at Texas City?
Texas City, yes.
Don't talk over each other.
After you left Texas City.
Let me ask a question here.
Yeah.
You represent this guy or not?
Who are you?
My name's Tucker, and I represent Ayrshire, and I just want to know if you represent the guy or not. I'm getting, if you don't represent him, you don't have any right to be making any objection. If you do represent him, tell us so.
Why don't you keep your mouth shut? I'll do what I want.
No, you're not
Oh,
going to do
yeah.
what you want.
Oh, wait.
I'll do what I want.
No, you're
No,
not.
you're not.
Yeah, I am.
That's
I'll make
bullshit.
whatever objections I want to make, and I'll make them as loud as I want to make them. Now, you need to shut your mouth, and we'll keep the record straight.
Don't tell me to shut my mouth, boy. Don't make me big, but you won't see how bad you are. Come on.
And I wouldn't try that, Ed.
Are you threatening to fight?
Hold on just a second.
No, I want to know whose side we're on. We're going to be outnumbered, Ed.
Hold on just a second.
No, you got a big mouth. No, you do. You need to either represent the man or not.
I'm
Not tolerate
representing
it.
Monsanto, and I'm
But
making
you're
an
not-
objection on the record.
Then you're not entitled to be his lawyer then,
I'm
okay?
not representing the man.
Well,
I'm
you're
making
trying
an
to be.
objection on the
And
record.
another thing,
Don't tell
you
me what
don't-
I'm trying to do.
yeah, I'm going to tell you something else. You don't run this deposition. You
Listen
understand?
to you, Joe.
You watch and see who does. Big boy.
I'm telling you, Joe.
Oh, you ain't telling me a goddamn
I'm gonna make
thing.
whatever objections I want.
You can make your objections and keep
talk as
quiet,
loud as you
see?
want. No,
But
I'm
don't be
not
telling
gonna
another lawyer to shut up.
Don't be
That
telling
ain't
me
your
to shut
goddamn
up.
job,
That's not
fat
your
boy.
job. Mr.
Now get back-
Peace.
Now you've got
As I
that
said
man
before,
for
you have an incipient bad
What do you want to do about it, asshole?
Oh, I'd like to knock you on your
Wait a
ass.
minute.
Come try it.
I'm not gonna do that.
Wait a
Come
minute.
over here and try it, you
Wait a minute.
dumb son of a bitch.
Wait just a second.
Come over here.
Hold it. Hey, wait a minute. Hold on. No way.
Get
Hold on.
close.
Hold on.
Why don't-
Hold on just a second.
Associate are taking Mr. Garrett out in the hall to lecture him on the code. They're doing this over our objection. We started this deposition, unable to get an answer from this man.
Unable to get an answer from this man. It's one of my favorite situations. So when we talk about depositions, you have the opportunity in a civil case to depose witnesses to find out what the evidence is going to be. I don't get a chance to do that in criminal law, but in civil law you do. And it's fascinating because you can find out a whole heck of a lot about people and about the situation prior to trial, so you know what the case is worth. So this also walks you through here the court procedure. When we're actually getting to a trial, it's pretty formulaic. You start with jury selection, or what's known as voir dire, opening statements, and then we take testimonial evidence. So folks will get to testify about what happened. They will testify and admit exhibits through that testimony. Then you get what's called a motion for directed verdict. That happens after the plaintiff's case, so they have the burden to prove that there was a violation of the law. If they fail to meet that burden, then the court may grant a motion for directed verdict. But if there's any question about whether or not the law was violated, it's going to go to the jury. Then the defense gets to put on their case. Then we have closing arguments. And then you hopefully get a verdict. And then lots of things can happen after the trial. Most civil litigation doesn't stop at the trial. It goes on motions for new trial, recoveries for costs or attorney's fees. Then the judgment finally gets executed, and then they have an opportunity to appeal it to the appellate court. Now, we have a crisis in our courts. California is a really great example. We have too many court cases for too few courtrooms, too few judges, too few lawyers. Well, not too few lawyers, but definitely for too few judges and too few courtrooms. So in 2017, these are the numbers that we had filed in the state of California. The ideal civil clearance rate is 100%. For however many cases come in a year, they are supposed to have that many cases go out. Our clearance rate isn't that good. In 2017, it was 75%, which meant that for every 4 cases filed, only 3 of those cases that had already been filed went away. And so you have this huge culmination of cases. And so there's this huge push at the trial court level to encourage people to use alternative dispute resolution methods to come to an agreement before trial becomes necessary. So in unlimited cases, that's where the recovery is more than, the recovery potential is more than $25,000. There is a 90% settlement rate prior to trial. For limited, which is above the small claims amount of $7,500 and below that $25,000 mark, the settlement rate is 83%. Now, what are the different types of dispute resolution? I'm only concerned with arbitration and mediation, okay? Your book lists a variety of other types that, absent it being a super expensive, really important case, read like Samsung versus Apple, nobody's doing those. Nobody has the money to do those. So arbitration and mediation is really where we have our ADR meat and potatoes. So arbitration will assist you in settling disputed questions of fact or law. And under arbitration, the parties agree to be bound by arbitration. It can be mandatory based on a contractual obligation or under the law, depending on what your case is about and where it came from. The only way that a decision by an arbiter can be overturned is if there's been fraud, the conduct or the decision-making was arbitrary, or there were significant procedural errors. Now, mediation is different. So an arbiter sits as a fact finder, fact decider, and makes a binding decision on the parties, versus mediation where the parties use a messenger to pass information, to pass offers between each other so that they can try to settle the case. And this person, the mediator, will be a neutral party who may make suggestions, may not make suggestions, the best mediators do, and really try to focus the parties on what's at issue and get them to an agreement. Okay, that is the end of this lecture. Stay tuned for chapters 4 and 6.